The information made available via this podcast is for informational purposes only and not for the purpose of providing legal advice. You should contact your attorney to obtain advice with respect to any particular issue or problem. Use of and access to this podcast or any of the email links contained within its website do not create an attorney-client relationship between Michael Dockins, Shoemaker, Lupin, Kendrick, and the user or listener. The opinions expressed at or through this podcast are the opinions of the individual author and may not reflect the opinions of the Shoemaker firm or any other attorney.
Hello, everybody. Welcome again to the 5th episode of Wrestling with the Law, a monthly show on ad-free shows, a bonus content show, if you will, covering the areas of law and wrestling. I'm Mike Dockins, the Gimmick attorney, a partner with the law firm of Shoemaker, Lupin, Kendrick. We are in Detroit, Toledo, Columbus, Ohio, Tampa, Sarasota, Charleston, now Greenville, South Carolina, and Charlotte, North Carolina. Today's topic is one that, again, I didn't know much about until researching it. And I had not heard anything other than, this guy gave the WWE, gave Vince McMahon a loss. That doesn't happen very often, but I didn't know what happened and I didn't know why. It's the case of Jesse G. Janos, also known as Jesse Ventura versus Titan Sports, also known as the WWF. The takeaway from this episode, I think you're going to find, is contracts matter. And you should have contracts, and your contract should spell out exactly what each side anticipates or expects or what things will cover. That is to say, you shouldn't assume. You shouldn't assume something is going to happen or that there is an understanding between the parties. You should have it locked down in a contract. I say it to my clients all the time, both inside and outside of wrestling, and this will kind of prove why. So a little bit of procedural history about this case. In December of 1991, Jesse Ventura sued Titan Sports and some other parties that were associated with Titan in Minnesota State Court related to royalties that he expected to be paid for videotapes that Titan had sold. Titan moved with the state courts of Minnesota to have it transferred away from them into federal court, and it was transferred. And then you had that case in the district court. Titan and Ventura both appealed the decision of the district court and moved it to the Court of Appeals. The Court of Appeals made their decision, which we'll get to in detail in a minute. And ultimately, as we all know, Jesse Ventura won. So Titan took the case then to the Supreme Court of the United States. They denied the request. And so that was it. That's where it ended. So the background. In July of 1984, Titan entered into a license with LJN authorizing the use of WWF wrestlers' likenesses on figures. At that same time, they also entered a license with DIC Enterprises, a master license agreement that covered t-shirts, trading cards, calendars, computer games, all sorts of other things. In December of 1984, WWF Titan Sports entered into a license with A&H Video Sales. A&H Video Sales is, as most of us know them, is Coliseum Home Video. And that agreement was for the production of, VHS tapes for wrestling matches and collections of wrestling matches. And it resulted in about 90 different VHS tapes being made by Coliseum Home Video. Ventura also started wrestling for Titan, for the WWF, in 1984, and he entered into an oral contract. So there was no written contract. It was a handshake deal between Jesse and Vince McMahon. And he wrestled with him, like I said, throughout 1984. And in September 1984, he had 3 consecutive losses to Hulk Hogan. And that particular set of matches, that rivalry ended because Jesse found out that he had blood clots in his lungs and he wasn't able to travel. It really kept him from performing in the ring and breathing properly and all of that. Interesting to note that Titan paid Jesse while he was recovering from those blood clots. And another interesting note, at least I think it's interesting, Jesse claimed that these clots resulted from his time in Vietnam being exposed to Agent Orange. I don't think that was ever proven. And it's been established that Jesse has a lot of stories from Nam and conspiracy theories and things like that. He's got all kinds of shows and podcasts and all of that. So whether or not it's true, I don't know, but he claims that it was his exposure to Agent Orange that ultimately led to those blood clots, which ended his wrestling career. So after September of 84, Jesse recovered. He returned back to the WWF, back to Titan, and returned to do some color commentary. when he was doing color commentary for them, he was paid about $1,000 a week. Again, it was an oral contract with Vince, and there was no discussion about that contract, or in that contract, I should say, regarding royalties being paid for videotapes or a license to use his likeness in videotapes or anything like that. So we get through the rest of 84, and in January 1st, 1985, Jesse signed he signed, I guess, a first, it's not oral, his first wrestling booking agreement, or WBA, with Titan, and he resumed wrestling. That wrestling comeback was rather short-lived. He did form a tag team with Randy Savage and Miss Elizabeth at his side, and for a while also had an angle where he was in a six-man tag with Roddy Piper and Cowboy Bob Orton. And they took on Hillbilly Jim, Uncle Elmer, and Cousin Luke. And there was an angle there, something about a wedding. I think it was Hillbilly Jim. I could be wrong. Somebody married somebody else. And as the story goes, at least according to Jesse, the state of New Jersey wouldn't allow a fake wedding to be recorded. So it was an actual wedding. The whichever wrestler it was, Hillbilly Jim or whomever, actually married their girlfriend and made it legitimate so that they could record it for this whole angle. Shortly after that six-man tag and that angle, Jesse had to retire. The injuries, the blood clots, all of that, he just couldn't do it anymore. He couldn't handle the travel. So he entered into, again, an oral agreement to do commentary. He hosted something called The Body Shop, which was a lot like the Piper's Pit, only it took place in a gym as the backdrop. And he became a color commentator on weekly television and things like that. In March of 1986, so a little over a year after his comeback, Jesse terminated his agreement with Titan, and he decided he was going to pursue acting. As we know, he was in a number of movies. He was in Predator and Running Man and things like that. But in the fall of 86, Ventura decided he wanted to return to Titan and continue to work for them as a commentator. Again, he came back, oral contract, no mention of royalties, no mention of licenses and things like that. Fast forward another year. So from fall of 86 to fall of 87. In the fall of 87, Jesse hired Barry Bloom, who's a name probably all of us knows. He's the super agent to wrestlers. I know Barry. I know him pretty well. He's a nice guy. Enjoy his company and enjoy working with him. I believe Jesse was Barry's first foray into wrestling, and his first foray into wrestling and wrestlers, getting them gigs and movies and things like that. But fall of 97, Jesse hires Barry to be his agent. Jesse told Barry he wanted to get back with Titan and to have his contract situation kind of locked down. So Barry negotiated on behalf of Jesse with Dick Ebersol, who was Titan's partner in producing Saturday Night's Main Event. But those negotiations failed. So that first one aired, or that episode of Saturday Night's Main Event anyway, aired, and Jesse wasn't on it. Weeks later, Dick Glover, the vice president of Titan's business affairs, reached out to Barry Bloom and asked about Jesse and wanted him back on the show and wanted him back in commentary. So Barry started negotiating on behalf of Jesse and asked about royalties. What about royalties on these sales and these products and these things that Titan is doing? And Dick Glover noted that Titan had a policy of only paying royalties to quote unquote featured performers. So that was VHS tapes that were best matches of Hulk Hogan, or best grudge matches, or best whatever. And so it was the featured performers that kind of focused on them, not really paying royalties on compilations or collections or things where there were a whole lot of wrestlers that were featured kind of separately without a focus. So Barry wanted to push this, so it seemed, and get Jesse some royalties, but Jesse said, no, I want to be back with Titan. I want to work there. I want to work on commentary. That's the policy. I'm not going to upset the apple cart. That's fine. Let's just, move forward. So he did. Jesse signed a contract with Titan, and in that contract, the right to royalties and licensing associated with his likeness, it was all waived. So he had no right to recover under that. So that again was fall of 87-ish, early 88. And Jesse worked with Titan and worked on commentary till about August 1990. At that time, Jesse left Titan and he went to WCW. In December of 91, so he'd been with WCW a little over a year, Jesse sued Titan in Minnesota State Court for royalties related to the videotapes that Titan had put out through Coliseum Video. Coliseum was also named as a party. That's neither here nor there. The original complaint that Jesse filed in Minnesota State Court had 3 causes of action. One cause of action was fraud. He claimed that he was defrauded by Titan and was owed money. He claimed there was a misappropriation of his publicity rights, his right of publicity. We've talked about that in previous episodes. Check them now in the archives. And he also made a claim of what's called quantum meruit, which is Latin for what has been earned. It's a common law state claim. It's similar to, and in some states different from, unjust enrichment, but that basically what it means, at least in Minnesota, is that Titan was unjustly enriched and took advantage of Jesse in some way, and he should get paid out and he should be reimbursed for that. So that was filed in December 91. Shortly thereafter, Titan asked the case be moved to federal court, and the case was then tried in federal court in the district court before a jury. When it came to that federal district court thing, the fraud claim kind of went away and the misappropriation claim went away. The only claim that was submitted to the jury was the claim related to quantum meruit, so related to the unjust enrichment. The jury of the district court awarded Jesse $801,333,000.06, so a little over $800,000 for defrauding Ventura for exploitation of his commentary on videotapes without compensating him. Jury also awarded Jesse a little over $8,600 for use of his name and likeness and voice in other merchandise, not necessarily the VHS. After the jury award, the district court concluded that actually, Jesse, you weren't entitled to a jury trial on the quantum meruit claim. Shouldn't have gone before a jury. So the judge said that jury verdict is vacated. But the court entered the findings of fact and the conclusions of the law that were consistent with the verdict. And basically the judge said, yeah, that don't count. What they said doesn't matter. We're throwing it all out. But guess what? By happenstance, by coincidence, I, the judge, am adopting everything they said and everything they found. So after that, Jesse requested that he get the pre-filing of the complaint interest. So he wanted interest on that money basically from the time that it all started happening all the way through when the complaint was filed. That was denied. He also asked for prejudgment interest. So from the start of the lawsuit to the time it took to get through the state court, move to federal court, through the federal district court and all of that, and ask for the prejudgment interest, that was granted. After the district court made its decision and entered these things, Titan appealed the entire verdict. They said, nope, this whole thing's wrong. District court, you screwed up. You shouldn't have done this. And Jesse himself cross-appealed, but he only cross-appealed for the one thing he lost, which was the pre-filing interest. So he had some dog in the hunt, but not much. He was okay with obviously being awarded all those damages plus getting interest from the time of the filing. So the appeal went to the Court of Appeals. And in that appeal, Titan raised three errors that they believed had happened. They believed that Jesse was not entitled to recover damages related to the pre-Bloom time, so 1985 and 1987, because it was provided for under an express contract. Express contract, Minnesota law says that if there's an express contract, then there can be no award for unjust enrichment, because there can't be an express contract, so a contract that says exactly what the terms are and what everybody expects and all of that. And then at the same time say, well, oh, by the way, there was also this implied contract. And in this implied contract, we are owed some sort of money under unjust enrichment. That's essentially what unjust enrichment is looking at. So you can't say that there was an express contract and an implied contract that cover the same subject matter. So that's basically what WWE was saying is, hey, there's an express contract. Therefore, you can't possibly find an implied contract. Therefore, there can't be an unjust enrichment claim. The second error WWF was hanging their hat on was that the district court shouldn't have applied this quantum meruit cause of action for commentating royalties and things like that from 1987 to 1990, also known as the post-Bloom hiring, because the court had rescinded the express contract to give the royalty awards. So basically what Titan was saying was the court then found there was an express contract, but then took it away, and they shouldn't have taken it away because the contract was there and the contract post-Bloom waived all those rights. Last, Titan alleged the district court abused its discretion in qualifying an expert witness that Jesse had used and relying on that witness to calculate the damages that they came up with. Again, Ventura's only issue on appeal was that he believed he should have received the pre-filing interest. So moving to issue 1, the pre-Bloom award of damages. So the court applied Minnesota law as they should have. And quantum meruit in Minnesota, it was well-established law even in the early 90s. And basically, Minnesota law said an action may be based on a failure of consideration or fraud or mistake. There's situations where it'd be morally wrong for one party to enrich himself over or at the expense of another. And the Minnesota law also said that one party benefiting from another is not enough. That party must be unjustly, meaning illegally or unlawfully enriched. So that was what the court was looking at. So the first threshold issue that the district court had to determine, and then the Court of Appeals had to affirm or deny or reverse, was whether or not Titan received some sort of benefit. Titan argued that it received no benefit from any of this, aside from the commentary services and appearances of Jesse at matches and during broadcast shows and things like that, as they were defined by his contract. So there was no benefit. They paid him. He was there to give commentary and to do appearances and things like that were outlined and expected of all commentators. And that was the benefit. They paid for it. They got it. There was no additional benefit. The court found that this interpretation was far too narrow. They said, well, maybe you did get those things. That's true. But the labor alone is not the benefit, but also there was intellectual property. There it comes again. There's intellectual property created by Ventura in his performance and his commentary. And the idea that Titan had received this benefit of intellectual property and the ability to exploit this intellectual property was the benefit on which a quantum meruit case can be made. So now that the court determined benefit, now they must determine, all right, was it an unjust benefit that Titan received? So for Ventura to win, Titan's rights must be limited so that it can't use performances in any way without Jesse's consent. That's what Jesse had to prove. And the court found that Titan's rights were limited by Jesse's right of publicity. He had a right of publicity that was kind of separate and independent from the contract. It was his right, and it was his right to decide how it was going to be used and if it was going to be used. And so therefore that right limited the rights of Titan to do whatever they wanted with the recordings, with the commentary, however, they weren't allowed to do it however they pleased. Interestingly, at that time in the early 90s, the Minnesota Supreme Court had never decided a case of misappropriation on the right of publicity. So applying Minnesota law, what the Court of Appeals or what the district court had to do was look at lower court decisions. They had to look at scholarly works. They had to look at dicta, which, if you don't know what that is, dicta is a portion of a decision in court cases, things that are precedential, that don't really have to do with the case and the law that's being applied or the law that is being created in some instances, the common law. It's just kind of other statements and other information. Sometimes it'll be part of a consenting opinion or a concurring opinion, or even a dissenting opinion. So it's not really part of the determination of what happens from the legal perspective, but it's language in there that maybe suggests something. So the courts had to look at that to determine, okay, would the state of Minnesota, would the Minnesota Supreme Court recognize the right of publicity and the misappropriation thereof? And if they would, how would they decide that? How do we think that the state of Minnesota would deal with it? The district court and Court of Appeals affirmed this. The district court found that the Minnesota, easy for me to say, Supreme Court would recognize the right of publicity, and that Titan violated this right by using Ventura's commentary without his consent. So they did it unjustly. As I noted above, even unjust enrichment is okay if there's no express contract. But Minnesota law says if there is an express contract that does not address the specific benefit, then quantum meruit is allowed. So Jesse could have had an express contract. There was a contract, oral or otherwise, between Vince and Titan, and that contract did say you're going to do some commentary, you're going to work on broadcast, you're going to do all these things, but it didn't say anything about his intellectual property, his right of publicity. his ability to license that and exploit it, and whether or not Titan had the ability to do that as they pleased. Therefore, the quantum meruit claim was allowed. The Court of Appeals noted that between 1985 and 1987, Ventura actually had two contracts. He had the wrestling booking agreement, the WBA, and he had the oral contract for commentary services. The WBA, the court found, clearly precluded royalties for the videotape exploits of Jesse as a wrestler. Had nothing to do with his commentary. They found that no agreement was in place regarding royalties per the commentary agreement. Again, it was an oral agreement. There was no discussion about that or anything like that. The court found that to be a fact, that there was no discussion regarding royalties pertaining to commentators. They also found, as a matter of fact, that Ventura couldn't be aware of impending VHS sales because at that time, in 1985, 1986, 1987, VHS sales weren't an industry practice. It was a relatively new technology at the time, and it wasn't a common thing that the wrestling companies had done, so Jesse couldn't have and shouldn't have anticipated. The district court thus correctly found that the oral contract didn't address royalties, and therefore Ventura could recover under quantum meruit according to his pre-Bloom contract. So that was issue one. That was the first problem that WWF had, and they lost. So issue two, post-Bloom hiring and the award of quantum meruit. So it's a totally different issue from the pre-Bloom contract, because the pre-Bloom contract was an oral contract. The post-Bloom contract was an actual signed contract, and that contract existed, and that contract waived the right to royalties. Bloom was aware of the Titan policy not to pay commentators. These are all things that didn't factor into the pre-Bloom days, but it did here, and they had to be analyzed. So the ultimate question, may Jesse avoid that express contract where he expressly waived royalties and recover monies for unjust enrichment? The Court of Appeals confirmed the district court decision that Jesse was indeed entitled to avoid that Jesse was entitled to avoid the contract because it was fraudulently induced by Titan, and he was allowed to recover reasonable value of the royalties. So the Court of Appeals looked at a couple of threshold issues. Was Jesse entitled to introduce evidence of fraud when the only cause of action was quantum meruit? Again, I mentioned before, when Jesse filed his state complaint, it included three different causes of action: fraud, misappropriation of right of publicity, and the quantum meruit claim. By the time it got to the district court and moved on, the fraud and misappropriation had gone away. All that was left was quantum meruit. So should Jesse have been allowed to then introduce fraud claim? And if he was allowed to, was the fraud claim and the evidence of the fraud claim sufficient to provide the facts for fraudulent inducement? So the initial Claude frame, easy for me to say, fraud claim was stricken from the original filing for procedural reasons. In the federal rules of civil procedure and all of this, you must state your claim with specificity and particularity. And so you can't just go in there and say, well, they defrauded me and I should get awarded money. You have to say, they defrauded me, and here's how they defrauded me, and here's why they defrauded me, and here's how the fraud harmed me, and here's why I should get recovery. He didn't do that. Basically, he just said, hey, there was fraud involved, and that was it. So it got stricken on a procedural matter, not necessarily on a substantive matter. In the quantum meruit claim, Titan raised a number of defenses. And one of those defenses was, doesn't count because it was covered by a contract. So they had a defense of, doesn't count, covered by contract waived royalties. Well, by bringing the contract in as a defense, what WWF did was open the door for an attack on the contract by Jesse. Jesse has the right to attack that defense. It's kind of like impeaching a witness. Hey, I'm going to bring this witness in, and this witness is going to talk about what a great guy I am and how I do all these nice things, and that I should be trusted, and I've never used a gun or done drugs and all of this. Well, I'm allowed to impeach that witness and say, that witness is a check forger and he steals money, and he does all these things that are untrue. He has all of these crimes of dishonesty, and a crime of dishonesty impeaches him, right? That so by the fact that he's talking all nicely about one guy, by at the same time being a known and notorious liar, impeaches him, maybe makes him less than credible. So this is similar to that. Titan said, hey, we've got this defense. I've got a contract. I'm using this contract and I'm enforcing it against Jesse. Therefore, he should not recover money. Well, by opening the door, by claiming the contract as a defense, Jesse got to attack the contract. So he was allowed to try and show that contract, hey, you know what? I was fraudulently induced into signing it. I never should have signed it. I wouldn't have signed it if this fraud hadn't happened. And so he was allowed to bring that evidence in. Counsel for Ventura was very intelligent and very directed and very deliberate by making statements to the court that, hey, we are not making a fraud claim. There is no fraud claim here. Quantum Meriwet's all there is. No fraud. Not going to bring fraud. This is merely impeaching that contract, undercutting that defense. And the court was appreciative of that and found that to be persuasive. And so we moved to the next step. What was the sufficiency of the evidence? So in 1987, Bloom negotiated these contracts and things with Titan. Found out about this policy that they only paid featured performers and the best of collections and all of that. So Jesse, based on wanting to be back with Titan, said, fine, I'll waive those. That's great. Let's go. Between 87 and 90, at least once a year, every year, Barry and Dick Glover would meet annually to discuss Jesse's contract and discuss the performance fees and any special performance payments that he should get, pay-per-views or extra things that he had done that weren't anticipated by the contract. And every time Barry testified, he asked if that royalty policy had changed. And each year, Dick Glover confirmed that only featured performers got royalties. So Ventura and Bloom relied on this. They said, you know what, the policy hasn't changed. We're not going to upset the apple cart. We're going to keep doing what we're doing, getting paid under this commentary contract. We're going to move on with our lives. Well, in reality, several royalty payments had been made that were inconsistent with this policy. So this policy had been and could be broken. And Jesse and Barry both testified that if this policy were different, they would not have signed the same contract. They would not have renewed the terms. They would have fought for and believed that Jesse's commentary had value, that he was a featured performer in some respects, but even if not, he didn't have to be featured. His contributions were important and he should have gotten royalties on VHS tapes. They were lied to. They were told that was the policy, that only featured performers got it, and that wasn't true. So the Court of Appeals affirmed the district court and said, you know what? We're going to set aside this contract. It was fraudulently induced. And therefore, the district court's award of damages under Quantum Meriwet is confirmed. So moving to the third area that WWE or WWF claimed they're on appeal that should have been overturned. They believe that the district court was mistaken in relying on testimony of a certain expert by Jesse Ventura. That expert witness that he brought in was someone by the name of Weston Anson. And currently, he's the chairman of Consor, which is an intellectual property consulting firm that specializes in trademark, patent, copyright licensing, IP valuations, expert testimony. It's headquartered in California, but they also have offices in New York and London. So clearly a guy that has credentials and has valuable credentials to be able to be an expert about damages and things like that. Titan argued that the evidence that Mr. Anson brought forth, specifically the market rate of royalties related to licensing IP, was irrelevant in this case. And they also said the evidence was impermissibly speculative. So they said Anson shouldn't have been an expert, but even if he was, the market rate of royalties information that he brought, the evidence that he brought was irrelevant, and that whatever evidence he did bring, even if it was relevant, was too speculative, and therefore it was just kind of throwing darts in the dark and shouldn't have counted. There's a big, long rules of evidence analysis that I won't bore you with, but the court ultimately found all the rules of evidence had been adhered to, and then proceeded with analyzing, okay, was Mr. Anson properly admitted as an expert witness, and did the information and evidence that he brought forth should it have been considered? And so they did that. The courts found that the evidence was relevant and that Mr. Anson's testimony was relevant because it was directed to a material fact. So it wasn't a question of law, it was a question of a fact in the case. And the jury or the judge or whomever has to decide, what they believe as far as facts are concerned and which side they side with in coming up with their decision and ultimate verdict. And the evidence that Mr. Anson brought provided a fixed value for the license and for the royalty. So it wasn't just the court shooting in the dark or Titan shooting in the dark or Jesse shooting in the dark. It was an expert saying, hey, here's based on my expertise in this area. Here's a value. Here's where I think the number should be or what it would be. And here's why. And they also, he provided evidence of the market value of Jesse's license to license his right of publicity. So Titan's arguments, all of which were rejected. So if you want to hang some L's on them, let's hang a couple more. They were rejected in this argument that the evidence was irrelevant because there was a negotiated contract. So they were saying, look, none of this matters. There was a contract, and you should be overturning this idea that the contract was fraudulently induced and thrown out. And you should find that there's a negotiated contract that was done at arm's length with an agent, people knowledgeable in the business. And therefore, it doesn't matter what the market value was. It doesn't matter what the fixed value is. This is what was agreed upon, and what was agreed upon was zero. Rejected. They also said, okay, all right, well, alternatively, if you find that there wasn't a contract or all of that, this evidence that Mr. Anson brought is wrong because Titan pays 5%. That's the royalty they pay. That's the number that should be used to calculate whatever damages, and that's the measuring stick. And these were rejected because Titan's cases were evidence, their evidence of 5% royalty, all of that is evidence of what a reasonable royalty might be, but had nothing to do with why Mr. Anson's testimony was irrelevant, right? In fact, what he was saying was relevant because he was saying, these are the numbers. This is a range. We'll get into that in a second. This is the range of what royalties should be. And so essentially what Titan was saying was, well, we've got our own expert. Our own expert is, us, because we've been doing this for a while and we now pay people, and the measuring stick is 5%. So then it comes down to the trier, be it the judge or the jury. Which person do we believe? Which expert do we believe? The battle of the experts. Whose percentage is right? Whose percentage is wrong? So had nothing to do with the relevancy of Mr. Anson's testimony. It had to do with their own evidence of what is reasonable. So having determined that the evidence is relevant, the Court of Appeals turned to whether or not the evidence was reliable. And when you ask about reliability of an expert witness and coming up with numbers and things, what you're really asking about are the methods and principles of which they derived this testimony, derived these conclusions, reliable? You're not looking at whether or not the conclusions generated are reliable. That's kind of what Titan was asking. Well, these conclusions are unreliable. No, that's not true. That's something that the court and through the process of going to court and litigation has to determine. It was not looking at, and Titan was not looking at, were the methods right? Did he draw this conclusion? Did he come up with these numbers based on some harebrained nonsense, or did he come up with it based on something that's reliable, makes sense, based on kind of current accounting principles or things like that? And the court ultimately found he did. So what kind of numbers are we talking about? So part of the evidence that came into this was sales figures. And so what kind of money did Titan generate from these VHS sales during the time period in question there in the mid 80s, based on 90-ish VHS tapes? And those sales were almost $26 million. Anson testified that royalties would probably fall somewhere between 3.5% and 7.5%, with 5% being what he would accept as a minimum if he were an agent for somebody in Jesse Ventura's position. So he actually fell in line with what WWF said was a reasonable royalty. So doing the math, the 3.5% of that number is a little over $865,000. The 5% mark is $1.25 million, a little less than $1.25 million, and 7.5 is $1.86 million. And how did Anson come up with this? No, he didn't just guess. Again, he didn't just throw darts in the dark like WWF almost suggested. His percentages came from surveys. He surveyed thousands of similar VHS license agreements, and he couldn't find any wrestling license agreements. Again, as I noted before, as the court noted before, that wasn't really part of the compensation model for wrestlers at the time. So he found what the court found to be reasonable corollaries. He looked at sporting agreements and what athletes and different things had done and what they had licensed. He also looked at other entertainment personalities and luminaries and similarly positioned folks to determine what are the numbers like? What does it look like for celebrities in kind of the sports and or entertainment, or in this case, sports entertainment, in those fields? And that's where he came up with 3.5 to 7.5, with his opinion being 5% is a minimum. And the court agreed. They found, you know what, that's reasonable. It's reasonable to do that. It's based on sound principles. There were no other wrestlers. And so you used good and relevant and sufficient information to make your determinations and come to your conclusion and your expert testimony. So the attack on Anson as an expert, well, the court found, I found this hilarious. The court found, wow, he's got a really impressive background. And not only does he have an impressive background, but in fact, his background is so impressive that he is more qualified than many other experts that the court has allowed in and allowed to testify. So he was in the upper crust of experts. So they found this to be a disingenuous argument by Titan. So again, the expert was allowed in. The number that ultimately led to the damages, which is over $800,000, as I mentioned before, all of that was valid. It was acceptable. It was based on sound principle, and the lower court, the district court, did not screw up by using this testimony and allowing it in. So the court basically said, hey, across the board, Jesse, you win. We affirm this as the Court of Appeals. We think the district court was right. They used good sound judgment, and they didn't make mistakes. So about the pre-filing interest that Jesse claims. Well, to succeed in a pre-filing interest claim, you have to your claim has to have been readily ascertainable by reference to objective standards. Well, what does that mean? It means that the claim that you had pre-filing, pre-complaint, had to be pretty easily determined and pretty in concrete what the claim was, what the amounts were, and why you should have been paid there. And because the royalty rate wasn't discernible, that's why we had to have Mr. Anson give testimony, why he had to testify to it and had to go through calculations and hand-wringing to get there. It wasn't readily ascertainable. Even Anson himself in his testimony speculated about what the range would be. So you can't say it's readily ascertainable. It is 5%. It is 3.5%. He said, well, 3.5 to 7.5, somewhere in there. And all of that ultimately had to be determined by the court. There was also no agreement as to royalties. There was no certain payment details. There were no time periods for accrual, and therefore very little about it was readily ascertainable. A lot of that had to be ascertained by the trier of fact, had to be determined in court to be able to get anywhere. So I said, sorry, Jesse, can't have the pre-filing interest, but you can keep that interest from the filing on. So like I said, in conclusion, everything was affirmed. Even what Jesse appealed wasn't overturned. Interestingly, the Court of Appeals had a dissenting judge. So it wasn't a unanimous decision by the panel of judges. One of the judges dissented. He said, you know what, we got this wrong, guys. But he was in a minority. So ultimately his opinion didn't matter. But Judge Morris Shepard Arnold said he believed that Jesse shouldn't get anything. He believed that Minnesota did not and would not recognize a right of publicity. And therefore, because there was no right of publicity, Jesse shouldn't be entitled to any money based on the oral contracts pre-Berry, pre-Bloom. But, maybe it would be allowed post-Bloom because that's something different. There was fraud in the inducement. There was a fraudulent contract. Therefore, there was no contract at all and, was being taken advantage of. He also said, look, for there to be unjust enrichment, there had to be some sort of extra services for which Jesse wasn't paid. And he didn't believe that happened. He said Ventura didn't provide extra services for which he was not paid. He provided his commentary, and he was paid for it. It was just the same services repackaged in VHS form. It was nothing different. He didn't have to go above and beyond to appear on those VHS tapes. It was what he did in the broadcast or on whatever recording, and then it was rejiggered and repackaged and sent on its way. That is not unjust enrichment. And he said, you know what? Titans should benefit from being able to repackage and manipulate that which someone has done for them, has been compensated for by them, and make money on it. They should be allowed to do that. They're entrepreneurs. Titan is the one who staged the matches. Titan is the one who hired the wrestlers. They hired the announcers, and they took all the risk. Right? What if nobody shows up at the show? What if nobody watches Saturday night's main event? What if there's no money made anywhere and no profit was made? They had all the risk. Jesse had no risk. Jesse's job was to show up and talk and do color commentary and be a heel and be entertaining, which he was. He got paid for that. Moving on. Titan gets the benefit of the rest. And the judge, Arnold, also went on to say, you know what? Even if Minnesota did recognize a right of publicity, and even if the scope of the license between Titan and Ventura was unclear, Ventura still shouldn't recover. Well, how does that make sense, right? He's almost talking out of both sides of his mouth, but he's not. He said Jesse was hired to provide broadcast commentary. Jesse himself testified to that and said, yes, I was hired by Titan Sports to provide broadcast commentary. And because Minnesota hadn't really addressed the right of publicity, Judge Arnold, wrongfully in my opinion, but I digress, found that right of publicity really isn't that different from the law of copyright. And so he relied on a leading copyright treatise. For any of you legal nerds and IP legal nerds like me out there, the number one treatise in copyright is something called Nimmer on copyright. And Nimmer is the author. Nimmer talked about this, not this specific scenario, but found that where there are ambiguous licenses for a copyright, or here right of publicity, that if it's ambiguous, the licensee, or here Titan, so licensor of the copyright, the licensor of the right of publicity is Jesse, licensor licensed to Titan, the licensee may reasonably interpret the license to extend to fall within the medium described in the license. So that is to say, because Jesse was hired as a broadcast commentary, it's reasonable and all right to say that broadcast commentary includes all manner of sort of transmission like that, which would include cable television as opposed to broadcast if they wanted to re-air it, or video cassette uses, or the sale of things like that. And so in this way, the court said, you know what, Jesse shouldn't have gotten anything. Titan should have been justified in what they have done and what they did, and they shouldn't have had to pay him. He was the minority. He lost out. Jesse wins $800,000 and hangs a pretty significant L on Titan. So that's it for this episode. I hope you learned something about this case. I know I did. I thought it was interesting, particularly that, Jesse had done a lot of work for Titan without a contract, and that contract didn't really address how royalties and things would work out. And he was kind of fighting against company policy, and, company policy didn't win out. And even when he did have a contract, he was fighting against company policy, but the company lied to him. They misled him. And therefore that contract kind of got tossed to the side, which meant he should get paid. So as I said from the beginning, I thought, the real takeaway from this, and in the contracts I've seen, the AEW contracts, the WWE contracts, the Impact contracts, they are very extensive and cover a lot of things about technologies now known or maybe known in the future, and address DVD sales and streaming and things like that, or try to carve things out. There was an interesting case recently about Bill Nye and Disney that might throw the whole idea of streaming is not its own sort of technology, that streaming is the logical and natural progression of DVDs and Blu-rays. It's basically video on demand that you pay to have a right to access. So if somebody can and has the moxie to take on WWE, that'd be interesting. That case was, I think, state court, or at least a lower court. So it's not going to be precedential in Connecticut, which is where all Titan, or I guess WWE conflicts happen nowadays. But it doesn't mean that the courts wouldn't consider it. It will probably be a matter of first impression for that court, and they might rely on that case, especially when you talk about people as sophisticated as Disney with the team of lawyers they have. But again, my takeaway was, look, you should have contracts. You should always have contracts. I tell clients all the time, I don't believe anything until I see it written in paper and both sides have signed it. It's easy to have an agreement with friends. It's easy to trust friends. But then what happens when you're not friends? What happens when you're not friendly? Having a contract, even between friends, is usually pretty easy to get into because you are friendly. And what I look at whenever I analyze a contract is, what's the worst case scenario? And how do I get out of this? And, what's the downside? That's what I get paid for, not to be all rosy and everything's going to be great and, be super optimistic. My job is to say, this is the worst case scenario. This is what could happen. And so in the contracts that I write, I don't try to be too heavy-handed. I don't try to add unnecessary clauses and things to complicate it and make it longer and, drive up the billable hours. But I do try to cover my clients in all reasonable fashions and in a way that's most protective for them. And sometimes when you're dealing with these big companies, when you're dealing with WWE or you're dealing with AEW, there's certain things aren't going to change. Man, they're not worth fighting, and you're not likely to get it changed. But the bigger star you are, the higher up the card you are, the more established you are, the more you can move some of those things around. And sometimes, in very rare instances, you can get some of those immovable clauses removed or moved more towards your position, but you can change your percentages on royalties and the amount you get paid or days you have to work and things like that. So, the idea is, have a contract, lock it in, get what's best for you, and don't just rely on handshakes, because at the end of the day, money comes between people. So that's it. That's episode 5. We can put this thing in the can. Apologize for being a little late this month. Went on a trip down to Jacksonville, went to Revolution and did some stuff for ad-free shows and met with a boatload of clients that were down there. Got some new ones too. And then came home, and after recovering from that, a week with Conrad and Silva and the boys, jumped right back on the vacation train and took the wife and kids down to Florida, also different part of Florida, to get away from the Northwest Ohio weather, get down to somewhere warm, get to a nice pool and hot tub and hang out. And I was thinking about recording this from my computer from poolside in Florida, but thought, the video quality would be crap, the audio would be crap, and I didn't want to do that. So waited till we got home. So here I am on a Saturday night recording this for you guys and gals. Hope you guys are entertained. If you have any questions, hit me up. Reach out on social media. At Gimmick Attorney on Twitter. Same thing on Instagram. GimmickAttorney.com will take you to my professional bio, and that's the best way to reach me. So this is Mike Dockins signing off for another episode of Wrestling with the Law right here on Ad Free Shows.